May I, Your Lordship?
Yes,
Lordship, I beg to mention item number 19, Your Lordship.
19.
Yes, sir. Here, I was supposed to get instruction from the department, Your Lordship, but we have not received any instruction from the department for the matter to be referred to the mediation or not, Your Lordship. So at least 3 weeks time may be given, Your Lordship.
Right, in the prayer of state, Lord Council appearing for the petitioner.
No, Your Lordship, for the respondent, Your Lordship.
You're for your government.
Yes, Your Lordship.
The responding, state government. Service is yet to receive the instruction regarding referring the matter to mediation. 6 for some time. Prayer is allowed. Let the matter be listed after 2 weeks.
Yes, Your Lordship.
In a date to be fixed by the registry.
May I beg your lordship?
Hmm.
Lordship, I would like to mention one criminal appeal. It's pending since January 2026, in which there is an connected.
Next week.
Can it be after tomorrow, Your
No,
Honor?
not this one. The next week. Let's see in the next.
Millet, if I may mention item number 20 on behalf of Mr. B. Picha. Lordship, he couldn't make it today due to health issue, Your Lordship.
Hmm?
Item number 20
Yes.
on behalf of,
From recovery health issues.
yes, Your Lordship,
On the prayer of Mr. Sorenso, appearing on behalf of Mr. B. Picha.
B. Picha, Your Lordship.
Learned Council appearing for the respondent. 6 sometime as Mr. B. Picha is having some health issues. Let the matter be fixed after a week. After a week.
Oblige.
Yes.
Your Honor, I beg to mention item number 25.
Hmm.
On behalf of Senior Counsel D. Majumdar.
Hmm.
Your Honor, due to some difficulties, he couldn't appear today. So kindly fix the matter on 21st of April.
Okay, on the prayer of Mr. Sorenso, the learned counsel appearing on behalf of Mr. D. Majumdar, the learned senior counsel appearing in the matter. Let the matter be listed on
21st of April.
21st of April. You have spoken to the other side.
Yes.
On agreement. On agreement by the respondent. Counsel for the respondent listed on 21st. 21st April. Yes.
Much obliged.
Lordship, I beg to mention item number 20 and 24.
Yes.
With consent of other parties, may be released after 4 weeks.
You are appearing for
For respondent number 1 and 2.
Mr. Sorenso appearing for respondent number 1 and 2 submits that submits with consent of the other side that the matter may be listed after 3 weeks.
4 weeks.
After 4 weeks, prayer is allowed. Let the matter be fixed. Let the matter be fixed after 4 weeks. Yes.
My Lordship, I beg to mention item number 21, which is listed for mediation. I'm for the appellant appearing on behalf of conducting counsel G. Kato. However, we are there's no scope of mediation between the parties, as we are not challenging the quantum of award, but the very mentality of it. So I humbly pray that the matter may be placed before the regular court for hearing, Your Lordship.
Ms. Sorenso, the learned counsel appearing on behalf of G. Kato.
Yes.
The learned standing counsel, learned counsel appearing for the petition, appearing for the appellant. She submits that she has instructions that the matter may not be sent for mediation before the mediation center. Guwahati High Court, Itanagar permanent bench. Full stop. She submits that the matter should be placed before a regular bench for adjudication. Full stop. There is allowed. Let the matter be listed after 2 weeks before a regular bench.
Obliged.
May it please your lordship. Your lordship, I would like to mention item number 15 for
Number?
15.
Yes.
For respondent 2 and 3.
Mhm.
Your lordship, today we are filing wakalat nama And your lordship, we have taken consent from other opposite party, and the matter may be posted for 18 March.
You are appealing for whom?
Yeah, respondent number 2 and 3.
Respondent number 2 and 3,
Yes, your lordship.
Mr. So-and-so, the learned counsel. Appearing for respondent number 2 and 3, submits that he has instructions to appear and file the wakalat number, file the power on behalf of respondent number 2 and 3. Accordingly, he prays for listing of the matter. When?
18 March, your
Listing
lordship.
of the matter on 18 March. He submits that he has already taken the consent of the council appearing for the petition. Full stop. Accordingly, let the matter be listed on so and so.
Much obliged.
Item number 1.
It is Lordship.
Yes.
Although this application filed without FIR, but I have been informed that yesterday evening, the same has been registered.
Hmm?
The FIR has been registered yesterday evening.
Hmm.
This application, when it was filed, there was no registration of FIR. In fact, the incident,
So you get the FIR and brought in record? Bring in record, sorry.
um,
You get the FIR and bring in record.
Lordship, apprehension is very serious. I'm a government servant.
I mean, since FIR has been filed, you get the FIR.
Lordship, the incident, it occurred on 6th of March. Today, we are in 10th. And repeatedly, police are calling me. They are coming to my residence. I'm a government servant, Lordship. At least some interim protection. I will file affidavit, additional affidavit, bringing the FIR. Serious apprehension, Lordship. Lordship, kindly see page number 15, Lordship. This is a case pending before the CJM. There is enmity between me and the other persons. I am the complainant. This is because this FIR counterblast. Nothing but a counterblast. Only altercation was there. In page number 17, Lordship, kindly see several missed calls, calling me to police station. There is certificate also. Under section 65B of Indian Evidence Act.
You're working as what?
Lordship, I am at Accountant General Office. My ID card is at Lordship, page number 19. I'm an accountant. Page number 19 is my ID card. In fact, the complaint is also from my office, and we reside in the same building.
Who is the complainant?
The wife of one Pradeep Kumar.
Yes, Mr. Louis.
Yes, Lordship, since there is no FIR, Lordship, only record may be called for Lordship. Status, Lordship.
At paragraph 5, Lordship, I have paragraph 12, I mentioned everything. What has happened? Paragraph 12. That thereafter on 7/3/2020 at 11:34 a.m. and 11:43 a.m., an unknown person from an unknown phone number being such and such claiming to be the investigation officer of the case and calling from Niti Vihar police station very sternly spoke to the applicant
Niti
saying,
Vihar where? In
Dot-
Arunachal, in Itanagar?
Niti Vihar, yes, Itanagar.
Hmm.
The applicant saying, Robin, तुम खुद थाना आ रहा है या हम लोग आएगा? Meaning, Robin, you are coming yourself to the police station or we have to come? And in this effect, I have placed a certificate also, screenshot of the call.
So we'll protect him for some time let him not be arrested
Yes, Lordship.
and let him file, since the FIR has already been filed, let him bring that on record and on the
Yes.
next date, as far as the bail is concerned, that will be considered.
Yes, Lordship.
At least till that time, we don't, because since he says the
Yes,
FIR has been
yes.
filed.
Yes, Lordship.
Okay, heard, Mr.
K. Saxena.
Huh?
K. Saxena.
K. Saxena, the learned counsel appearing for the accused applicant. This is also heard Mr. D. Louis, the learned PP for the state. This is an application under 482 of BNSS 2023 for granting anticipatory bail to the accused applicant. Full stop. The case relates to receipt of certain phone calls allegedly from
Niti Vihar PS.
Niti Vihar police station, asking the accused applicant to appear before the police station regarding an FIR which was supposed to have been lodged by one,
Pradeep, wife of Pradeep Kumar.
by the wife of one Pradeep Kumar. Full stop. It is due to the aforesaid calls, the accused applicant being apprehensive of his arrest has filed this FIR, instant pre-arrest bail application. Full stop. The learned counsel appearing for the accused applicant submits that he had to file this pre-arrest bail application without the copy of the FIR due to the fact that though his best efforts, he could not procure the FIR till the time he filed the instant application. He submits that he has received information and instruction that the FIR has already been lodged and he is willing to bring the same before bring on record before this court. However, till the time he gets the copy of the certified copy of the FIR, he prays that the some interim protection should be granted to him as he is receiving constant calls from the police officers searching for him. He submits that in fact the issue goes back to a dispute between the accused applicant and the wife and
Their neighbors.
wife and one person and a wife of Mr.
Pradeep Kumar,
Pradeep Kumar,
Rohit Kumar,
for Pradeep Kumar and Mr. Rohit Kumar.
and one
Rohit
more.
Kumar, which is pending before the
CJM, UPI.
CJM court UPR. He submits that due to the pendency of the case, which was registered due to an FIR lodged by
It's a
the
complaint case.
accused applicant,
Complaint case.
when a complaint lodged by the accused applicant,
Yes.
there is an existing hostility between the parties, and due to the aforesaid fact, this false FIR has been lodged by the aforesaid persons. Full stop. In view of the aforesaid submissions and submissions, this court of the considered opinion that at this stage, no coercive action should be taken by the police officers. police officials on the accused applicant, full stop. In the meantime, the case is to be produced before this court on the next date of listing, as well as liberty, as well as the accused applicant shall bring on record the FIR that has been lodged against him. Full stop. Let the matter be listed on when?
On 17, Lordship. 18, Lordship, 17th, Tuesday.
On 18. So let the matter be listed on 18. Full stop.
Definitely, highly obliged.
Item number 2.
Yeah, please, Lordship. Lordship, this is a joint petition for passing and setting aside of a charge sheet number 01 of 2025 dated 9/10/2025, registered as drawing PS case number 55 of 2025 dated 14/8/2025. Lordship,
What is the issue?
Lordship, the brief.
What happened?
Yes, Lordship, actually, Lordship, there was a car accident between the petitioner number 2 and the deceased person, that is the husband of petitioner number 1. And on the spot, due to the severe injury,
He died.
yes, he died
So
on the
it's a
spot.
negligent driving.
Yes, Lordship, however, they have settled the matter outside the court due to
Can you settle it? Rash and negligent driving.
Lordship, because actually it was the deceased person who drive on the wrong side, Lordship. And that's why there was a kabang.
That will be investigated.
Yes, Lordship,
Who is wrong, who is right.
yes, and
But
Lordship,
now you have settled by what? How you have settled it? You
Lordship,
paid some money.
yes, Lordship,
How much?
8 lakhs has been paid to the deceased family. So as they are living in the same locality, Lordship.
No compromise and no quashing in rash and negligent driving. See, tomorrow we are going to pass a judgment in the same matter. So tomorrow it will be listed, and this matter also will be dismissed
Yes,
accordingly.
Lordship.
So you have some submissions to make. You make it. We'll close it.
Yes, Lordship. Since Lordship,
See, we have taken a decision. This court has taken a decision. Then when there is a rash and negligent driving, a person is died.
yes, Lordship.
You cannot just compromise it by paying some money.
Yes.
That will be a wrong precedent. Then what happens is that like if somebody is a victim, a poor person, a rich person will come and like he'll pay some money and close the case.
Yes,
So
Exactly.
that kind of compromise cannot be allowed.
yes, Lordship.
And this is the view of this court, of course. I mean, I do not know what other these things, but criminal jurisprudence and criminal justice cannot be bought by paying some money.
Yes,
So, I mean, this is
American society.
something which has a lot of impact on the society.
Yes.
And it will send a wrong message that somebody who is a rich person, he will come and, he will do some accident by his own rash and negligent driving. Then some poor fellow will die and they will come to that family and like tell them, we want to compromise and we want to pay you some money. The victim's family will accept it, whereas the victim is no longer there to compromise.
yes,
The
Lordship.
victim is already dead. So he is not there to consent. Somebody else will consent, or his family or whatever. And with some money, they will consent it. This is not the way to do it.
Uh,
So there was a case, I have reserved a judgment.
Yes.
So I have given I've given a quite a bit of thought on this. And then after looking into various cases of Supreme Court, we are passing an order. Tomorrow we'll get this order.
Matter
So-
is already charge sheeted.
Yes, whatever, charge sheeted, not charge sheeted, that is not anything.
Uh,
But thing is that we have come to a conclusion. Tomorrow it will be delivered.
Yes,
So since the matter is there, that's why I'm saying so.
yes,
So, we are of a different view.
yes, Lordship.
But one view was taken by this court. This court has also taken a view earlier,
Yes, Lordship.
following another decision of this High Court only. But now we have come to, because there are lot many cases, Supreme Court cases, we have not discussed at the point of time. So we have gone through those cases and we have come to a conclusion. So what we will do, we will reserve it, and after the declaration of the tomorrow's case,
Yes, Lordship.
then we'll pass an order in this. Okay. You write, heard Mr. So-and-so, the learned counsel appearing for the petitioner, also heard Mr. Gitado, the learned APP for the state. Then you write, heard the submission of, heard the submissions of respective counsels appearing for the parties, judgment reserved.
Deeply obliged.
So you don't have any other submissions to make, right? Only the compromise, the money is paid.
Yes,
That is what, right?
yes.
Item number 3.
Application under 520 DNS.
Hmm?
Application under 520 of DNS.
Mhm.
The party of the someone dated 05/03/2020.
Impugn someone. Why you have come for some, I mean, against someone only?
This someone has been issued violating the provision of section 194 of the DNS. And this is at the stage of preliminary inquiry. And at the preliminary inquiry stage, someone cannot be issued. And moreover, this someone has been received by the petitioner for WhatsApp. And it is certain law that someone received for electronic media is not permissible. There are 3 grounds with challenged by the petitioner for this application.
Okay, we'll issue a notice on this.
My lord, my only, at this stage, my lord, my limited submission would be, my lord, may kindly allow me to get the instruction, because, my lord, under section 195 notices, someone has been issued. So 195 notice can be issued only in case of death, unnatural death, that is directly connected with section 194. So whether there is any death of the person or there or not, because non-mention.
Since they have not mentioned anything about anything in this, someone etc. It is silent. There is no whispering of the book. This someone has been issues after complying the provision of section 194. They have simply
No, are you aware of the incident? What has happened?
No, Your Honor. I have no idea.
You don't have any idea.
Your lordship, in that case, my lord, pass over for the timing, I will get the instruction whether there is any case of death or.
Let him take instruction.
Yes, madam.
We'll take it up after some time.
Yes, madam. Obliged.
Can you find out, I mean, what is the case all about?
Okay, madam.
Why someone has been issued?
Yes.
He's saying that he's totally unaware.
Okay, madam.
Item number 4.
Mid please, Lordship. So what happened here in Milot, there was a 164 proceeding Milot and the earlier 145. And there was an executive magistrate order challenging which Milot I went to the district judge Milot in a revision on the ground that the respond number 2 Milot has already instituted a civil suit claiming declaration of right title interest and the possession. Now in session of the matter, the executive magistrate cannot go ahead with the proceeding. The learned district judge very rightly has quashed the proceeding. But however, while quashing the proceeding has made certain observation, he ought not to have done it. Because when the court has said that it is the civil court who is the competent jurisdiction to decide the issue, there was no requirement of giving any observation on the merit of the case.
What were those observations?
Page 14, page 117, here certain observation has been made with regard to the petitioner that he had a history of disposing. Now, the question was
Page
page 117, paragraph 8,
117, okay.
117.
And these comments were made by the learned
District judge.
district judge.
Yes. Now, before that, Milord will come to page 118.
Then let us see what are the objections.
No, below the decision. The decision what has been taken by the district judge, if it's read with that observation, Milord, it was not called for. Therefore, Milord, 118 first. Page 118, paragraph
That's what
11.
I wanted to see.
Yes.
Yes, 118. Yes.
118, paragraph 11, Milord.
Paragraph 11, yes.
Yes. There is no doubt that the dispute between the parties in the present case is relating to right title and ownership and not only for possession. Assistant Commissioner Nahalagan, while exercising jurisdiction under 146 BNSS, can adjudicate dispute relating to possession only and not ownership over the immovable property. There are catena of decision of the Honorable Apex Court and the different high courts on law on point. The Honorable Supreme Court, by judgment and dated so and so, by judgment or an order passed in so and so, have discussed and hold that where a civil suit for possession or for declaration of title in respect of the same property is initiated, then the proceeding under 145 shall not be allowed to continue. It is also held by the court that there is no scope to doubt or dispute the possession of the decree of the civil court is binding on the criminal court in a matter relating to right title possession of a property. Parallel proceedings should not be continued and the order of the learned magistrate shall be quashed. It is also held by the Honorable Supreme Court that once the civil court is seized the matter, it goes without saying that the proceeding under 145, 146 cannot be proceeded and the same must come to an end. It was further held by the Supreme Court that the civil court would be most appropriate forum to take care of the grievances regarding the dispute over the immovable property and pass such interim order would reasonably protect the interests of both the parties. In the present case, as the dispute between the parties is relating to the immovable property and the right title and ownership with possession, hence the same can be decided by a competent civil court having jurisdiction. An assistant commissioner by the executive magistrate has limited jurisdiction while adjudicating dispute under 146 BNSS. The respondent number 2 so and so has already initiated a title suit 2 of 2026 along with an injunction application before the Court of Civil Judge who has jurisdiction to decide the dispute between the parties. In view of the above, the proceedings under before the executive magistrate so and so is quashed. The parties shall appear before the Court of the Learned Civil Judge for disposal of their grievances. Learned Civil Judge shall hear the parties and pass appropriate order regarding injunction or appropriate decree in the suit. Till passing of any appropriate order, the parties are directed to maintain status quo upon the suit property. It is specifically ordered that none of the parties and their representatives shall enter the suit premises or undertake any construction activity. Now, my lord will kindly come to page 118, my lord.
Yes,
Paragraph number,
118.
page 117, sorry. Paragraph number 8.
One one seven is what? This is what?
This
This-
is, my lord, the part of the impugn order, my lord.
Part of the imperial?
Yes.
Okay.
Order starts from page 114,
1107, yes. Page,
paragraph number 8.
8. No, paragraph 8 is not in page
But 117.
117. Yes.
Just prior to the decision, my lord. 118 is the decision. My lord finds 117.
Yes.
Paragraph number 8.
Hmm.
It starts from after hearing learned counsel.
Yes.
After hearing learned counsel appearing for the parties, I have carefully perused the record of the case and observed that the petitioner, namely so and so, this is the petitioner before your lordship, by deed dated sold the suit land to the respond number and she has occupied and possessed the suit land. It has further observed from the record that the case of the petitioner Tabatake tried to occupy and disposes the respondent on several occasions, and later on Tabatake sold the same land to respond number 3. Now the respond number 3 is trying to dispose the respond number 2 by constructing houses structures over the suit land. It is observed from record that the case that the learned civil judge has passed the decree on so and so, but in the decree there is no schedule showing that the suit land is covered by the said decree. Moreover, the said decree was passed by the civil judge in against Techi Mania and not the respond number 2, and as such the same is not binding upon her. It is further observed that the by judgment and decree passed by the learned civil judge, only right title interest was decided in favor of Tabatakar, but there is no decree in regard of possession of the same. Record reveals that Tabatakar on previous occasion has tried to dispose Teche Mania from a suit land, which seems to be a near present suit land and and several proceedings before the executive magistrate has taken place. It is observed from the record that he has a history of entering into land forcibly and constructing building and structures by obtaining favorable orders from the court. Similarly, the present case record also shows that after obtaining the stay to the order of the status quo passed by the so and so, the petitioner respond number 3 has started construction over the suit land to forcibly dispose the respond number 2. Now, my lord will kindly come to this suit, my lord. What is the prayer in this suit, my lord? Page 93.
Yes.
Well, the Lordship has read that the learned judges have came to a finding that I have already sold this land to the plaintiff of this suit. Now, the plaintiff praised, my lord, decree of specific performance of sale deed passed in favor of the plaintiff and against the defendant number 1, thereby directing him to execute registered sale deed and get the registered sale deed dated 10/3/2015. So this is, my lord, a dispute which has to be decided. Whether the sale deed was rightly executed, whether there was a transfer by person to this sale deed or not. And my lord will come to page 94 with regard possession, my lord, the prayer with regard possession. 4, serial number 4. Confirm or restore possession of the suit in favor of the plaintiff. There are contradictory prayer.
It was filed by whom, sir? I mean, the petitioner.
No, this
Filed
is
by the
filed by
other
the other side. So now, my lord, my limited grievance is that, my lord, that as the title suit is being filed, questioning the title, my lord, when the title is being clouded, now that title has to be decided by the civil court, and that is the competent court. The Lanad district has rightly said that it is the civil court which shall
But
decide.
he has gone into the merit of it.
Yes, my lord. My lord, my only apprehension is that while deciding the
should not
title
be
suit
there.
and the injunction, the learned trial court, civil court should not get influenced by this order. And that will not prejudice anyone, my lord. My lord, that's my own limited prayer.
Yes, you are opinion for?
Lordship, for respondent number 2, no. I'm the plaintiff in the lordship
Yes.
suit, lordship. Basically, lordship.
See, it's basically nothing to do with facts or something like that.
Yes.
I mean, it's only on the thing of the legal issues.
Yes.
Legal issues is that there's a plain file for a specific performance, or like, I mean, that has to be decided.
Yes, I.
That has to be decided.
Yes.
And there was a ground taken that since, I mean, this executive magistrate is not competent to do that, he has limited jurisdiction. So matters should be, since civil court has already seized the matters should be heard by the civil court, not, I mean, executive magistrate doesn't have any power.
Yes.
So accordingly, that matter should be decided and sent it back to the competent court,
Yes.
which will hear it. Now, thing is that, like, while doing so, there are certain remarks has been made, certain observations have been made, which talks about the merit of the case. And actually, the merit of the case has to be decided by the civil court.
Yes.
Because those issues were not before the concerned court which has passed this order.
Yes.
So in view of that, don't you think that these remarks are unnecessary? I mean, on the merits.
Was on these hours. Basically, whether it was sold to me or not, lordship.
Hmm?
Whether the suit lane, lordship, whether it was sold to me or not. Regarding that facts, lordship, that fact is already narrated in the petition itself, lordship.
Hmm.
The real petition. Basing on that only this observation has been made, lordship.
Petition has
And
been,
basically what happened,
no,
lordship?
petition has been filed by him, right?
Him, revision petition, lordship.
His revision petition. But in his revision petition, he has stated so.
He has stated, lordship, it was sold.
So let's see. Page 20, or not 20 is the judgment. No, not 20.
I think that actually even the copy.
In fact,
Now I just took.
my lord, you're not fine.
See, you have,
Primarily, you're not fine.
Hmm.
My stand, which would be in my written statement, that at page 3, paragraph 3. I'm disputing the sale deed on the ground that
no, that is perfectly fine, but if there are certain facts you have narrated yourself, and those,
no, that's
only those facts were, I mean, taken from there.
no, that's the observation made by the Lanark district judge is based on that there is a sale deed. There is a sale deed. I have not disputed the execution of the sale deed. I have questioned the sale deed on the ground that there was a sale transaction between us, which was subsequently withdrawn, as the sale consideration was never been paid.
So you came for a specific performance.
Yes, basically, therefore, he has come up for a specific
You came
purpose.
for a specific
Yes.
performance.
Lordship.
But no, just a minute.
Dear Lordship,
Oh, yes.
the order to be passed by the learned civil court, lordship, that will almost will prevail over the order to be order passed by the criminal court, lordship. That is the law, lordship, and that part law has been already, lordship, stated in the paragraph 11, lordship. otherwise also lawsuit.
No. I mean, see, the basic issue is that
Suppose
whether those observations were correctly made or not, whether those observations should have been made or not. That is the limited point he is raising.
Very limited.
Now, only thing is that you are saying that in the plaint itself for specific performance, which has been filed by him.
No, suit is filed by him.
Suit is filed by me.
Ah.
Revision petition has.
Sorry, revision petition which has been filed by him.
Yeah.
That those facts were narrated. Facts were narrated as well. Can you show me from?
Lawsuit actually,
That's not there.
that he has not annexed the, all the documents lawsuit. Anyway, lawsuit, let's, as proposed by my plain lawsuit, the matter may be disposed of with direction lawsuit, while considering my suit and, the IA, interim injunction. The Lalit Court below will not be influenced by this order lawsuit.
That's all, my lord.
I
That
think
will
that is
do.
the.
That will do, my lord. That will do. That is my
And so for the
apprehension.
interim is concerned lawsuit. That lawsuit may observe the interim will continue as directed.
No, that's, my lord, I'm not even praying for setting aside that interim. The, my
That
lord,
part-
the-
that
Let
part-
yes.
let those things be there. I mean,
yes,
I
the,
mean, only thing is that, I mean, those that Lanet civil
The-
judge should not be influenced by the observations made in paragraph so and so.
or your lordship will say, the learned civil judge will not get influenced by the judgment, this judgment. That's every, my lord, it will protect his right also.
The additional observation lawsuit. So for the interim is concerned, because he is the one who is raising construction over the disputed land lawsuit.
So that's already,
Therefore, observation, the interim as directed by the Lalit Court.
No, interim, you see, I mean, we are not touching on the interim because interim is already.
already passed by the
already passed
revisional
by-
court.
Yes, yes.
Passed by the revisional court.
Yeah.
So we should not, I mean, bypass that order or whatever, like, why should we?
And that is, my lord, that is already continuing till the disposal of the injunction.
Yes.
Eight, nine, ten. Eight, nine.
Okay, take down. Heard Mr. B. Kaushik, the learned counsel appearing for the petitioner, also heard. You are appearing for?
Yes, Tapini.
Sorry,
for this-
Estafette for respondent number?
Two.
Respondent
For
number
one
two.
lawsuit.
And MSL Hage for respondent number 1. Then this instant application has been filed under section 528 of VNSS 2023. 23, assailing certain observations made in the order dated 4/2/2026 passed by the learned court of district and session judge, capital complex UPA in criminal revision number 01/2026. The case of the petitioner is that petitioner is the absolute owner of land measuring 26,888.35 square meters at helipad area Naharlagun, district Papum Pare. His title and possession over the said land was declared by the civil court in title suit number 19/2017, which decree was affirmed by the appellate court, that is Guwahati High Court, and finally by the Supreme Court of India, thereby attaining, Supreme Court of India, thereby attaining finality, full stop. It is stated that respondent number 2 raised a claim alleging the purchase of the portion of land and lodged a complaint on which proceedings under section 164 BNSS were initiated by the executive magistrate who passed an status quo order dated 23/12/2025, full stop. Aggrieved by the aforesaid status quo order, the petitioner had filed criminal revision petition number 01/2026 before the district and session judge, UPR. It is stated that during the same period, respondent number 2 had also filed TS number 02/2026 before the civil judge senior division UPR seeking specific performance and injunction. However, in the aforesaid TS number 2/2026, the civil court issued notice but refrained from granting any interim injunction. Full stop. The criminal revision number 1/2026 was heard on 4/2/2026 and thereby, which was the court revision for district court. District and session judge, district and session judge, capital complex UPR passed. Now, what was the line everything? Hard on so and so, and passed an order whereby the learned court quashed the executive magistrate proceedings, holding that the dispute is essentially a civil in nature and pending before the civil court. Therefore, the executive magistrate doesn't have jurisdiction to entertain the matter. Full stop. It is the case of the petitioner that while passing the aforesaid order, which has been rightly so by the district and session judge, the learned district and session judge has exceeded his jurisdiction by making certain observations on the merit of the dispute in paragraphs 8, 9, 10 regarding certain alleged sale and possession of the same by respondent number 2. And also, he has directed status quo also.
Yes, but that status.
Then status quo, you'll have to challenge that.
No, that will continue till the disposal of the injunction. But what my grievance, apprehension is,
Oh, that is the interim order.
yes, that is the interim order, that is protecting him.
Okay. And further directed the parties to maintain status quo. Parties to maintain status quo. Full stop. Next para. The learned counsel appearing to the petitioner submits that he is not impugning the merit of the order dated 4/2/2026 passed by the learned district and session judge, UPR. However, what he is challenging is the unwarranted comments that has been made, unwarranted observations that have been made in paragraph 8, 9, 10 of the aforesaid judgment and order dated 4/2/2026, which may ultimately influence the learned civil court hearing the title suit number 2026. Hearing the title suit number 2/2026. He submits that that is purely a matter which has to be decided on merit, and since the learned district and session judge has not was not supposed to go into the merit of the dispute. He didn't have any business. He did not have any business to observe the past some observations on the merit of the case, which is pending before the civil judge bracket senior division. Therefore, he submits that the order should be passed, the order should be passed by this court, whereby to the effect that those observations shall not influence the learned civil judge senior division UPR in adjudicating the matter, that is title suit number 2/2026.
And connected miscase number 64 of 2020.
And connected miscase number 64 of so-and-so. Mr. D. Tapak, the learned counsel appearing for the respondent. What will be your submission? You don't have any objection to that. Submits that he doesn't have any objection in passing any order as prayed for by the learned counsel appearing for the petition.
But the interim passed by the learned.
That will be always there. I mean, that will be
We're
always-
not interfering
We
with
are not interfering with any interim order. We are just talking about that he should not be influenced by that. Nothing else, nothing. We'll record his submission. However, he submits that the interim status quo order that which has been passed by the learned district and session judge should be maintained. Correct? Should be maintained. First. Next para. After hearing the submissions made by the council appearing for the respective parties, this court is of the considered opinion that the learned district judge, learned session and district and session judge's comments in the order dated 4/2/2026 is purely unavoidable. Is purely avoidable. Therefore, this court directs that the learned civil judge in bracket senior division UPR while hearing the matter, that is TS number 02/2026 along with miscase number so and so, he shall not be influenced by the observations made in the paragraph in paragraphs 8, 9, and 10 of the judgment and order dated 4/2/2026 with the aforesaid direction.
and decide independently on its own merit.
And decide the matter independently
On its
on
own
its own merits. In its own merits. Okay. Then you write, in view of the aforesaid direction, the instant criminal petition is disposed of in the motion stages.
Lordship, since that submission has been recorded, so Lordship may object, however, the interim order passed by.
That's what I've written.
No.
I've given,
That shall be maintained by the parties.
that I have, okay, because of your submission.
Yes,
Okay. Then you can
because
write.
my submission has been recorded.
Or Lordship will say that we are not interfering with that order.
No, simple. Lordship.
Because, my lord,
However,
reiterating,
See, I mean, one already order is there.
Yes.
He's-
my reiterating would,
He is not challenging. the
I'm not
order.
challenging.
Correct.
He is not challenging.
Sometimes-
Your submission is you're making.
For clarity, Lordship, for
No,
clarity.
no, not required. I mean, unnecessary, we should not. pass.
My lord,
Because-
my lord, reiterating sometimes by a higher court always is
It's not
influential.
required. If the status will be there.
Since that's not going.
Or your lordship will say that as the petitioner is not challenging that.
Then you write, in the para you write, it will not be influenced. Then after that line you write that this court has not commented anything on the merit or other directions, merit or other direction passed by the learned district and session judge.
Grateful.
That will do.
That will,
So you have not anything to say.
deeply obliged.
So yeah, we have disposed it of. Okay.
Close, my lord. Deeply obliged.
Item number 8 is a bail hearing.
May I please your lordship? I'm representing the bail applicants in item number 8 and 9, your lordship. They're both under the same FIR 53 of Itanagar Women's Police Station.
I can't see you, Mr. Counsel.
Oh no. Wait. Oh no. Your lordship, apologies, there's something wrong with my camera. If your lordship may kindly pass over the matter and I'll enter through the.
Without seeing you, how can I conduct a case?
Yes, your lordship. Apologies, Your Lordship. Kindly allow me to enter through other device.
I see, otherwise also, I mean, notice on respondent number 2 is yet to be served.
Right.
So the matter.
Your Honor,
We'll have
Your
to wait.
Lordship, the
Yes,
service has
service
already
awaited,
been
my
done.
lord. Service awaited, my lord. We have forwarded the notice to the concerned OC, my lord. We have await for the service.
Yes, Mr. Counsel, what are you saying?
Yes, Your Lordship, the service has already been done through the registry, Your
What,
Lordship.
what has been done?
The steps has been taken, Your Lordship.
The steps
Towards
has been
respondent
taken.
number
What this court is pointing out that only only taking out, I mean, taking the steps will not do. The notice has to be served. It's a POXO matter, right?
Yes,
Are you
Your Lordship.
hearing? Am I audible? Okay, your
Yes,
name,
yes, Your
your name,
Lordship.
your name, please. Your name.
Nakato, Nakato. Yes, Your Lordship,
Right,
Nakato.
heard so and so for the petitioner. For the applicant, accused applicant. Also heard Mr. T. the learned ABB for the state. So office note dated 9/3/2025/26 reveals that service on report of service on respondent number 2 is still awaited. Full stop. Let the matter be listed. Let the matter be listed in the let the matter be listed on 18th of March.
Yes, madam. Obliged, madam.
Much obliged, Your Lordship.
The same, I mean, two matters, right?
Same, my lord. 18 and 9.
18 and
Yes, Your
19,
Lordship.
same. Okay.
8 and 9. 8 and 9, madam.
8 and 9,
Yes.
yes.
Obliged, madam.
Same order. 18 and 9.
Item number 3, it's a pass-through matter.
My lord, I've taken the instruction, my lord. The case is related to allegation of forgery, my lord.
Forgery.
And for that preliminary inquiry is going on.
Hmm.
But my lord, not for the unnatural death. But so far as this notice is concerned, my lord will find in the top of the notice, it's written
Page.
page 24, my lord. Annexure 1. Under section 195 or BNSS, my lord.
So it has been wrongly sent.
Wrongly sent. And my lord, one more issue is there, my lord, I would like to bring to your lordship notice, my lord.
Hmm.
During the course of preliminary inquiry, my lord, to my humble understanding,
There
my
is no
lord,
requirement.
there is no any power for the police to issue summon as well as notice, my lord. Because, my lord, I've come across a judgment from the Madras High Court, my lord, wherein every judgment, Lalita Kumari judgment has been considered, even the definition of investigation has been considered, wherein it was held that at the stage of preliminary inquiry, there is only limited scope that the police has to ascertain whether there is a commission of cognizable offense or not. They do not have any power to issue summon or notice, my lord. So now, my lord, this practice is going on in our state, my lord, very unfortunately, because this is the second time, my lord, I am dealing with the same case, with the same accused. Earlier, 41A notice was issued prior to the filing of the registration of the FIR.
Okay.
Now, again, in this case, my lord, preliminary inquiry is going on, and under section 195, notice is issued to the prospective accused, that too, my lord. My lord will find normally the notice is issued under section 100 on BNSS, my lord. My lord, directly come to purse, my lord, let us go through the provision of 195, my lord. If your lordship allow, I will read out, my lord.
See, 195 notice has to be issued in the case of
194.
194. 194 is regarding
Death,
suicide and
suicide, unnatural death, my lord. basically.
unnatural death.
Yes, my lord.
So there is no unnatural death involved in this.
Yes,
case.
exactly. It's a allegation of forgery. Yes. And my lord,
So section 195 notice summons could not have been issued.
yes, my lord. And secondly, my
On
lord,
that ground only we can, I think I think
interfere, yes.
we can interfere.
Yes, my lord.
I mean, we don't need to go into other.
Yes, yes. Yes.
At this stage, we don't need to go.
Yes, my lord.
So we can quash the summons.
Yes, my lord.
Set aside and quash the summons.
Yes, my lord.
Heard Mr. I Bam, Mr. I Bam, the learned counsel, appearing for the petitioner. Also heard Mr. T. Ete, the learned council, learned APP for the state, full stop. This is an application under section 528 of BNSS 2023 for 2023 for exercising the inherent powers of this court for the quashing the notice stroke summons for appearance issued under section 195 of the BNSS 2023 in connection with Itanagar, ITA stroke PS stroke GDE number 18 stroke 2026 dated 11/2/2026 issued by the, is it inquiry officer or investigating officer? It is mentioned.
My lord,
inquiry officer.
actually, my lord, he should be the inquiry at this stage because in FIR is not registered. So he's the inquiry officer. Later on, my lord, once registered an investigation.
Okay, by the inquiry officer, comma, police station, Itanagar, Arunachal Pradesh, dated 5/3/2026, which has been received by the petitioner through WhatsApp on 6/3/2026. Full stop.
My lord, on WhatsApp through this staff, my lord, official staff, not by the police, my lord. It's probably.
WhatsApp on so and so as forwarded to him by his office staff.
Yes.
So WhatsApp was sent to his office staff, then office staff has sent to him.
Notice was, my lord, submitted before the, my lord, his office, my lord, not him personally, but to the office, my lord.
So and so. The learned counsel appearing for the petitioner submits that he is totally unaware why the notice under section 195 of BNSS was issued to him. He in fact tried to gather information about the same from the inquiry officer. However, with his best efforts also, he could not do so. Full stop. He submits that he is not involved in any case wherein a summons under section 195 of BNSS could have been issued to him. Full stop. He submits that since he is not aware of the allegations made and the allegations against him, so you are not aware, no? I mean, you don't receive anything else. You don't have any other information. No. Since he's not aware of any allegations against him on the basis of which the notice could, the summons could have been issued. At this point of time, this court requested the learned APP to take instructions about the offense so alleged against the present accused applicant. Full stop. The learned APP T88, and then next paragraph, right? T88, the learned APP on court's request obtained the instruction, and he has intimated before this court that the allegations against the accused applicant is something to do with
Forgery, my lord.
something to do with forgery, and not something which not some offense wherein a notice under section a summons can be issued by the inquiry officer under section 195 of CRP of BNSS. This court has heard the submissions made by the counsel appearing for the respective parties. Full stop. a summons under, right, a summons under section 195 of BNSS can be issued by a police officer proceeding under section 194. Full stop. Section 194 of BNSS relates to inquiry in the case of unnatural death like suicide and or suicide or any death under any death under unnatural circumstances. Full stop. In the instant case, as submitted by the learned APP, there is no allegations against the accused applicant of committing any offense which needs to be inquired under section 194 and thereafter issue summons under section 195 of BNSS. In view of the aforesaid, this court is of the considered opinion that the instant application can be disposed of. The instant petition can be disposed of at the motion stage itself as agreed to by the council appearing for the respective parties. Full stop. Therefore, it is this court sets aside and quashed the impugned summons to appearance. It was dated when? Dated
5/3.
5/3/2023.
26, madam.
26 issued under ITA/PS/GD number 18/2026 dated 11/202/2026. Which has been issued under section 195 BNSS. In terms of the aforesaid order, the instant criminal revision petition is disposed of.
Madam, criminal petition.
Criminal petition is disposed of. I mean, that is sufficient, I think. We
Yes,
don't need to go into much in the, and you have taken proper instructions, right?
Yes, my lord. There is no any,
It should not be found out later on that
no, my lord.
we have gone ahead with your instructions.
No, my lord. It's
We
the
believe in TAPA.
actually, my lord, the allegation is he has obtained his job by using a
Some-
manufacturer ST certificate, my lord. That is the allegation. So there is no any question of unnatural death.
They must have got the format from somewhere and they sent it.
Yes, ma'am.
Without looking into whether it's 195 or
Yes, ma'am.
some other, right? Okay. Okay, we have disposed it.
Yes, ma'am. Obliged, ma'am.
Item number 10 and 11.
May I, Lordship?
Admission, no?
Your Lordship, this item number 10 and 11 are connected matters arising out of same FIR.
Hmm.
And Your Lordship, this anticipatory bail is the subject matter of joint causing petition. Your Lordship, which is item number.
These two are anticipatory petition. No, one is criminal petition.
One is Your Lordship anticipatory bail and second is causing petition, criminal causing.
Okay, what is the matter? Why are you seeking anticipatory bail?
Your Lordship, there was chances that she may be arrested, but now both the parties have already settled the matter, Your Lordship, amicably. And item number 11 is the causing petition, Your Lordship, joint causing petition.
Okay. What are the offenses?
Offenses were trespass, voluntary causing hurt, theft, assault, and criminal intimidation, Your Lordship.
Anybody died or serious?
No, Your Lordship, no. Actually, Your Lordship, the accused person is the mother of 8 minor children and
Accused person is the mother of
8 minor children.
8 minor children.
Yes, Your Lordship.
And
you-
she is accused, yes. Then-
And it was like, it was alleged that her husband abandoned her and children and living with the complainant's sister. Therefore, the accused person went to the house of complainant and to resolve the matter, Your Lordship. And during this visit, that verbal altercation took place and the present FIR was lodged, Your Lordship.
Okay.
That's
Now the husband has come back or he still there?
he came back, Your
He
Lordship.
came back.
Yes,
He has come back.
yes, Your Lordship.
He has come back to the children.
Yes, Your Lordship. That's why, Your Lordship. And informant is the petitioner number two in this causing petition, Your Lordship. Joint causing.
Okay.
This two matter should be taken separately because one
But
is
if it is, I mean, if it is quashed, if the compromise has been done, if it is quashed, then AB application will not survive.
AV is very serious, involves very serious matters because
AB by whom?
Uh,
For whom?
AV
Accused person, Your Lordship.
Accused is, I mean, that lady.
mother of
Yes, mother of 8 children.
What is serious?
serious is that earlier she was granted an interim protection by district and session court. Thereafter, she didn't cooperate with the IO on
We-
2 occasions.
Okay, then tell me.
And though she appeared before the IO, but she hid everything. She only didn't went to the house of the informant.
But those are informed, see, those may be the factual things. Correct, factual things. But now since they have settled it, if I allow this criminal application, criminal revision petition, what remains?
For that, updated CD is required because CD at this court, before this court, is
No, this has been,
24th of
no, this is, no, where is that agreement that you have settled?
Your Lordship, it's in annexure number 2, page number 32 to 34. In joint causing petition, Your Lordship.
I mean, is anybody, I mean, it's a joint petition.
Yes, Your Lordship. Item number 11 is joint petition, Your Lordship, by the informant and accused person.
she went with other goons along with 6-7 persons
Correct.
to vandalize
Correct.
the house.
Mr. APB, try to understand one thing. Now, if it's a joint petition, correct? If the court thinks that this petition can be allowed because they have come up with a mutual agreement and they have settled their disputes and they are husband and wife.
Yes.
Correct, they are husband and wife.
No, she is informant is a elder sister of that
Accused.
no,
No,
that who having a relationship with the husband.
See, informant is the
Elder sister of
elder sister of one
Younger.
one lady where
whom
allegedly having-
his husband has
allegedly
having illicit
some
relationship.
relationship with.
Yes,
right? An accused person is the wife.
wife,
Wife.
wife of the
And now the who are before this court? Before this court is this accused person, that wife.
yes, and another one is
Informant herself. Your
informant
Lordship.
who is the elder sister of nothing to do with the case, but
And-
her house was vandalized and threatened, intimidated by putting machete on the neck of the eyewitnesses who is a minor child, and the husband and that eyewitness father is a Indian National Army who is serving at JNK. In his absence, everything took place. And now they are in big trauma and under some
Then,
living successful
husband
life.
is not before this court.
No, Your Lordship, because there is nowhere mention about husband in FIR. Your Lordship, informant is the petitioner to herself. Joint petition.
Informant has nothing to do with this case, anything extramarital.
The
affairs.
informant has filed the FIR. That's why the case is.
Yes, because her house was vandalized and her minor children was threatened. She had a cut injury. There is a photograph also. It clearly reflects IO status of the case. That similar nature of the 3 different case pending in is registered in another PS also and
Against her.
against her. Habitual offender And she says in his petition, bail petitions,
No, she has
that
gone.
she
on-
went alone, but
She has gone only to the husband because husband was having an alleged affair.
no, from
And,
CCTV.
and she has
footage is
many
also
husbands
there.
or what? He goes to
CCTV
different places.
CCTV footage is also there. They went, she along with 6, 7 persons went with 2 vehicles and enter with the deadly weapons.
Whether husband has filed any complaint.
No, yours.
No, this lady whose house, where she went,
Correct. Now, this lady is agreeing that like, I don't want to go ahead with the case. Why husband did not file any FIR, did not file any FIR then? If there are certain serious allegations against the lady of attempting to kill him
yes.
or he has been
there is
injured,
allegation also.
why he hasn't filed any FIR? Now, the statement before this, what is the?
Lady has filed the FIR.
Hmm?
This lady, victim lady has filed the
The
FIR.
lady has filed, the lady who has filed this FIR, now she is saying that I don't have any issues with them and they are readily living together now happily. Is it so?
I have taken instruction from the IO concern that the charge sheet is ready to file
Hmm.
with option open to file supplementary charge sheet because her statement is not yet recorded,
Hmm.
accused statement.
And
See,
what-
in spite of having interim protection from this court, also till now she doesn't appear before the IO. She's intentionally evading court.
Why are not appearing?
No, Your Honor, she appeared before the IO 3 times, Your Honor.
Hmm.
No, in earlier occasion when
Only
interim
at
protection was
three
granted by session court.
Hmm.
But after that bail was cancelled later on,
No, where is that, this thing, that agreement, settlement?
Agreement is in page number, Your Lordship, annexure number 2, page number 32. We have original one also with us.
So what do you want, Mr. See, there is an amicable settlement happened. Now, if you are objecting it to it, then we'll have to put it for hearing.
Yes.
The case.
and updated case status might be
But
called.
Your Lordship, this is a matrimonial dispute, Your Lordship.
The matrimonial dispute,
It's not connected with
but,
matrimonial dispute.
But, see, usually in the case, there are no objections from the PP, usually. Wherein there are offenses which are something which can be compromised. Now, he is having serious objection to this, the lady, the conduct of the lady, this and that. So, your matter can be considered, but not today. Let him come with this
Updated status
updated
report.
status report.
GD entry, Your Lordship, kindly.
If the parties are amicably settled, husband is happy, then why, it cannot be done? And it's not a serious offense. It's some dispute between husband and wife, allegation of extramarital affair, staying with somebody else. And she is a mother of 8 minor children.
And money was robbed from her house during that incident. 4 lakhs.
Money was robbed from her house.
Yes, by
But she doesn't have any problem with that.
Yes, Your Lordship.
She
But-
has settled it.
she having a
Yes, Your Lordship. In
Injury
settlement
and-
agreement.
Are you appearing for the, you are appearing for whom? You are,
Ampur state, Your Honor.
Hmm.
State exists because crime exists.
Hmm?
State exists because crime exists.
Yes.
So this is a criminal offense against whom
The-
3 more cases are
she-
pending, and that means she is a habitual offender. So-
But, no, see, I mean, we are not concerned with other cases, okay? We are concerned with this particular case. In this particular case, the informant, I mean, whatever the materials, which are before this court it shows that it is a kind of a matrimonial dispute. Matrimonial dispute meaning thereby is that, I mean, that there is an allegation of some extramarital affair, and this lady has gone to the house of house where this husband was staying, and at that point of time, on the spur of the moment, she had to go with somebody. She went with some other people, and maybe some altercation happened, some assault happened. In those assaults, somebody must have got injured. Correct. Now, FIR was filed by one lady who was the owner of the house. Now, FIR was filed and police started investigation. Now, during the investigation, this person who has filed the FIR and and this lady who is accused, they have come to a compromise, saying that now there is dispute is over. We don't want to go ahead with the dispute because I mean, we have amicably settled this, and this is not a crime, such a heinous crime, and wherein the murder is involved, wherein rape is involved, where is some big commercial transaction fraud has happened, or some special some offenses and some special acts have been done. Nothing like that. It's a small issue, matrimonial issue, which was between husband and wife, but it has gone to some other person's I mean, life. Now, only thing is that these two persons have agreed to amicably settle it. Now, where is the involvement of the state in this? Is this something which is going to impact our society?
Yes, this improvement herein is nothing to with any matrimonial disputes.
This informant,
Is nothing to do with any matrimonial dispute.
and that's why she's settling it.
And why?
That
she-
is why she's settling it. And what is your objection to that?
That means she is like similar nature of case, 3 case. She means she can go anywhere, anytime.
You are in other cases. Who is stopping you?
As per your
No,
this is
no.
the previous.
I mean, you have serious objections. That's why we are not disposing of this matter. But
Yes,
it is that
bail may be,
I am just trying to understand
yes.
that, I mean, what is the
This
process in this?
interim protection in AB is also already there.
Hmm.
That may be comply with.
Hmm.
She has to appear before the IO.
She is appearing, no?
Yes.
No, no.
3 times already.
3 times she said she has appeared. I mean, your case diary says something?
Yes,
You have the case diary?
yes, in the court record.
Yes.
Entry 10.
Huh?
Sorry. And
So she is saying she is appearing after the interim order. You are saying she is not appearing.
no, after getting interim protection from this court, she never appeared.
After getting the interim protection from this
court.
she did
No,
not
yes,
appear.
I have taken instruction from the IO.
Yes, madam, why she is not appearing? Then we'll cancel the
Because your
bail.
lordship, settlement,
Entry 15.
Then we'll cancel the bail application if she is not appearing.
no, your lordship, because interim was granted on 2/2/26. And
No,
set-
I mean, see, I mean, if you make some statements, I mean, both of you make some responsible statements. PP is saying that after getting the interim protection, she was directed to be appear before was there any direction?
No, yours.
I have taken instruction.
No. Was there any direction from the court to appear? I mean,
Yes,
how to
yes,
appear?
yes.
Where is that? Let me
Last
see.
time it was,
Let me see. Where is the order? Which date?
order is,
No, 2/2.
2/2/26, yes.
Applicant shall cooperate, then applicant shall cooperate with the investigation, appear for investigating as and when called for. Applicant shall not directly, indirectly, okay. I mean, whether you have called her.
No.
Mr. PP,
Yes.
there was no direction to her to appear before the before the investigating officer, correct? Direction was to the effect that applicant shall cooperate with the investigation and appear before the investigating officer as and when called for.
Yes,
Whether you have called her,
yes.
where? You show me.
Serve the notice under 35, subclause 3 of the BNS.
Notice was served.
Yes,
And that-
twice served. It
Huh?
was served twice.
Served twice, but she did not appear.
Yes,
No, Your Lordship, it was never served after the interim protection, Your Lordship.
Record is there, Your Lordship.
Okay, we'll see the record.
Last entry is dated
That, that,
Yes, 14,
14/1/2026.
yes, 14 September.
Order was passed on when? Order was passed.
Two, two,
2/2/2026.
yes,
But this is 14/1.
14,
And she appeared already on 14/1, Your Lordship.
See, this is case diary of 14/1/2026. It is prior to the interim order, correct? This is a case diary of 14/1/2026. And it is prior to passing of the interim protection. Correct? So
suppose
do you have any instruction that
I-
after, no, you said that
yes.
after the interim order, she did not appear. Where is that?
Because till now she never appeared.
No, you are
Till-
saying that
till
like she
today.
did not appear. I mean, where is the direction of appearance? There is no direction of appearance. You said section 35 notice. Where is that? Where is the notice?
Notice it was there.
It is there. You just find out and then show it to me. Give it to him. You show it to me that section 35 notice was issued and same was received by her, and in spite of that, she did not appear before the investigation. You show me that. If there is any violation of the court's order, then obviously this NTCP bail application will be, whatever the protection has been given, that will be cancelled. But you show me that there is a violation.
One I found in actual form, but there were two. One is in file as case diary entry.
You show from the record that 35 or section 35 notice was notice was issued, and that was received by her. In spite of that, she did not cooperate with the investigation. It is as simple as that. I mean, you show me that. I mean, not only issuing the notice, you show me that she has received it. Hmm.
One copy is available, but another copy there is in GD entry. Somewhere in GD entry.
This is also prior to this thing, prior to this order. This order was passed on 27/2/2026, the interim protection. Correct. Now, you have been submitting from the very beginning that in spite of the interim order, she has not been appearing. You said, wait, you said that 35, section 35 notice was issued on her. In spite of that, she has not appeared. But the certain section 35 notice which you have shown to me, this is prior to that.
Your Lordship, my humble submission is that I have been told by telephonically that till now she didn't appear before the court, PS, and they are ready with a
See,
charge.
I mean,
They are ready with a charge.
Are you going to believe whatever the investigating officer is saying? Are you not going to ask him to substantiate whatever he is saying? Are you not going to ask him that give it on record, whatever you are saying? I mean, now, maybe the IO has told you, but there is nothing on record. This section 35 notice was issued prior to giving the interim protection. And in the interim protection, which has been passed by this court, there was no direction to her to appear. The direction was to cooperate with the investigation. Then you show me a document showing that she has been served the notice after this interim order, and in spite of that, she has not appeared. Then I'll cancel this interim, her interim protection. But you have been submitting that she has not complied with the IO's, section 35 notice. But that is not so. You could not show me anything. So you'll have to be careful, Mr. APP.
Generally, when there is a interim order, we prosecutions office do not take any steps regarding that. Only the petitioner who avail this, who was granted in interim protection shall avail before by going and appearing before the IO. And
See, there are certain directions. In fact, this code when passes an order in AB cases, in all of the AB cases, when interim protection is granted, this code passes an order to appear within certain dates, certain time. Okay.
yes,
But there may be certain courts, it's on the discretion of the court. The court may not think that like, okay, that appearance is not required. Only, but cooperation is, the order of cooperation is given. So order of cooperation doesn't mean that she will voluntarily go. If you ask her to come to the police station, if it doesn't come, then then there is a violation.
yes,
But
exactly.
when there is no notice from section 35 on record, there was no, material on record saying that she has been called by the investigating officer and she has denied that, she has rejected that request, then there will be a different case. But in this case, there is nothing on material.
Exactly. Other than that, there is nothing.
There may be some, misunderstanding, but see,
Yes,
there are two kind of orders. One order says that you go and appear before the IO
left out.
within 10 days of passing of the order. Correct? And certain orders may be there is no order for appearance, only the order for cooperate with the investigation. And this is specifically stated that where is that order? Specifically stated that the applicant shall cooperate with the investigation.
Yes.
Cooperate doesn't mean that you'll go voluntarily. If you are requested, you'll be there and appear before the investigating officer as and when called for. Now you show me from the record that you have called, investigation officer has called her, but in spite of that, she did not appear before the investigating officer. Then, see,
Yes, regarding that,
this
there
bail,
was no any
the
record.
bail and everything is a matter of personal liberty.
Yes,
Correct. So person is given bail after consideration of material before this court by the High Court. Now, it's not it's not that a routine kind of thing that you come to the court and say, no, she has not complied with the interim order, it should be cancelled. It's not like that. There has to be some material, some substantial material before you showing that she has not appeared and she has not complied with the direction given by the High Court while passing the interim bail passing the interim bail order.
exactly.
So if you do not have that material, then it will be difficult. So now bail thing is concerned, I don't find any material on record saying that she has not appeared. Correct. So we will pass an order saying that if at all required, because if this petition, criminal petition is allowed, then every petition may not be required.
Yes, that become in practice.
That
yeah.
will become a infraction.
Yes,
In this
at
case-
least this update that status report may be for and next that may be fixed for disposal.
And see, we have this court has
Because there is
this court has in so many cases passed the order while there is a compromise and the case is not of a serious offense.
in
And between matrimonial issues, then villagers, then all these things.
in
And on record now, I have we have found that there is an amicable settlement.
Yes,
And
if
on-
there is any amicable settlements, but ingredient of 307 was also there in the CD. That is recorded by the IO.
What
And
is,
that
what is 307?
attempt to murder,
Attempt to murder.
yes, somewhere it is written not only once, 2, 3 times.
But this,
That's
it is
that's
not
why
in
your
FIR,
lordship,
your,
updated status report may be required.
it was not in FIR, your.
And in judgment,
And ingredients from where you have got the ingredients.
that is as per the CD.
Was there any allegation in the FIR?
Intention was to,
Then let them file and, I mean, if there are ingredients, they'll file a charge sheet.
yes,
They'll file a charge sheet.
they inform me that's
They'll
ready.
file a charge, let them file a charge sheet. But this case, I mean, there is nothing in this case, I'll dispose of this case.
Yes, you will.
You can go to, I mean, if you think that there is a wrong order has been passed, of course, there are upper forums.
No, that is not intention. I just want to bring
Correct.
into
No,
the clear picture of the,
Now compromise has been made. It's a small, I mean, tussle between parties. Anyways, I have given sufficient time. I usually give time to lawyers so that
Yeah.
lawyers can tell whatever they feel like.
thanks. Yeah.
So, I mean, these two orders, I mean, you have any more submissions to make on the petition, criminal petition?
No.
Then we are going to
Done.
dispose it of.
Yes, as per,
We are going to
any
dispose it of,
appropriate-
and AB application also, we will pass some order. Because if FIR is quashed, then whether AB will be, Mr. Lohi, AB will be still required, order will be passed. Any order will be required to be passed?
No.
Hmm?
Options lordship.
Hmm?
If this petition passed.
But still she may have in apprehension, it seems like.
Yes.
Okay, we'll pass some order. I mean, these two matters, I mean, write the names and we'll pass the order in the channel.
obliged.
We have given sufficient time. I don't want to waste many time because I think all the Mr. MS Hage and all are waiting. Their turn to come, right? Anyways.
Yes.
Lordship, I'm extremely sorry, Lordship. I have a small prayer in item number 2, Lordship.
Which one?
Item number 2.
Oh.
So there's item number 2, Lordship. There is an instruction from the client, Lordship, to withdraw the petition. So, Lordship, I humbly pray that, Lordship, I may be allowed to withdraw the petition.
That criminal revision?
Yes, Lordship.
Motor accident?
Yes, Lordship.
Okay. Item number 2, you just change it on the prayer of heard Mr.
Tigao, Lordship.
Gao, the runner counsel, appearing for the petitioner. He submits that he has instructions to withdraw the instant criminal revision petition. Prayer is
Lordship.
allowed. The matter is dismissed on withdrawal. As withdrawn.
Lordship, criminal petition, Lordship.
Criminal revision.
Lordship, if required, liberty may be given, Lordship.
No, liberty, I mean, is always there. If you want, if you can file it.
Yes, Lordship. Deeply obliged.
Item number 12.
That, Jumbi, that file is with, file is in the chamber, so just bring it in. I thought.
May I, Lordship?
Yes.
Lordship, item number 12, by order 27/2 of 2026. The Honorable Court has, by order, given me protection.
Hmm.
And Lordship, this is a matter relating to an, there is an allegation that there is an,
That suicide case?
Yes, yes,
Minor
yes.
suicide.
Yes.
So we have allowed. the
yes, Lordship. It
application
was
since-
supposed to list along with the AV 16 and
Hmm.
18, but it has been missed out this time. In Lordship, this year, I don't stay even in the hostel. I'm like, I come from the,
You are who?
I'm a teacher in that school, Lordship.
Okay.
Like I come from A sector, Naharlagan.
Ah.
So I do perform my duty from Naharlagan A sector and I go to the school. Only thing in this case is that, Lordship, I'm the head of a action committee in that school. I've been given to function as a action committee. That's all, Lordship, my duty. While interact,
Okay, we have already
Yes.
directed other persons to teachers to go on bail.
Yes.
So we'll allow this. Also.
Yeah.
Okay, Jimmy, that yesterday we passed two orders. no? Similar order will go with this. The two minors.
Lordship, the
Yes, yes,
copy is here.
used to be-
Yes, the copy.
You give it to me. So you are also one of the teachers.
Yes, Lordship.
This order will go. Same order will go. Okay, we'll allow this.
Yes, Lordship. Heavily obliged.
Order is in.
Item number 13,
Lordship, I'm appearing for respondent number 1 and 2. Some more time may be given to file reply, Lordship.
You need time to
3 weeks, Lordship.
Hmm?
To file reply, Lordship.
file reply.
Yes.
You are Mr.
Devoid, I am for this appellant. Here, Lordship, I have an objection. This is the case of 2023. And for the last more than 2 years, it has been pending here. And on the last occasion also on 21/11/2025, there's short time for filing affidavit. And this time also they are taking another term. Otherwise also,
Why are you not filing?
Lordship, we are yet to get instruction.
What get instructions? I mean, you cannot keep on saying that I haven't got instruction, I haven't got instructions. You have taken time 18/8/2025 also.
yes, many times.
The last opportunity. It will be last over. You are appearing for respondent number,
What the respondent?
Huh?
For both the respondents.
both the respondents. I mean, this is the last opportunity. Heard Mr. You are Mr.
Devoid,
D. Bose, the learned counsel, appearing for the appellant. Also heard Mr.
S. Irang, Lordship.
S.
Irang.
S. Irang, the learned counsel, appearing for respondent numbers 1 and 2. The the learned counsel appearing for the respondent submits that he is yet to receive the instructions to file a reply to the reply in the instant. It's a reply or it's an objection? What are you going to file? Reply to what?
To their objection.
they are supposed to file affidavit in opposition.
There is an affidavit in opposition or objection, whatever. Reply, no reply. He's seeks time to praise for that he's yet to get instructions to file file objection in the instant case. Full stop. The learned counsel appearing for the appellant has pointed out that several occasions time has been granted to the counsel appearing for the respondents to submit his objection, but till date, no objection has been filed and the matter is pending since 2023. 22, full stop. Taking into account the aforesaid submissions, this court is of the opinion that a last opportunity may be given to the accused, last opportunity to be given to the counsel appearing for the respondents to file any objection in the instant case. To file an objection in the instant case. Accordingly, let the matter be listed after 2 weeks.
Lordship,
2 weeks, and it is made clear that this is that this opportunity is the last opportunity given to the respondents to file their objection in the instant case. In the event of non-filing of the objection, the matter will be taken up for hearing. It will come into admission. Huh? It will come into admission, right?
Yes.
The matter will be taken up for admission without the objection.
Lordship, there is an interim order.
Interim order so passed earlier shall continue till the next date of listing.
Highly obliged, Lordship.
Matter number 14,
Lordship, here, Lordship, a notice already been served to victim, Lordship. Today, Lordship, victims has not appeared, Lordship. So next date may be fixed for admission hearing, Lordship. Next date may be fixed for admission hearing because service already been completed, Lordship.
Heard Mr. Swainson, the learned counsel appearing for the appellant. Also heard MSD, Ms. Al-Fagir, the learned counsel, learned APP for the state. The learned APP submits that report of notice on respondent number. Respondent number 2.
Yes, Lordship.
Respondent number 2 has been received
Yeah.
by your office, huh?
Yes, Lordship, to the PP of,
By her office. And by the office of the learned, PP,
yes, Lordship.
PP, Government of Arunachal Pradesh. However, none appeared for the respondent number 2. For the interest of justice, let the matter be fixed on
After 2 weeks, Lordship, no date,
25th March.
Lordship.
25th March.
Much obliged.
much good. Matter number 16,
Please, madam. This is the victim.
Not appeared.
Okay.
Today I am first time appearing on the instruction of my client, Lordship. Okay. Heard Mr. So-and-so, the learned, Mr. J. Sharing, the learned counsel appearing for the petitioner. Also heard Mr. D. Loi, the learned PP for the state of Assam, as well as Mr. T. Topu, the learned counsel, who learned counsel appearing for respondent number 2. No, informant and victim.
Not impeding responding as a
Okay,
party.
you are not impeding. Okay. For the informant, full stop. The learned counsel appearing for the informant submits that he needs some time to. You are going to argue. Lordship, before next date, I will file the Wakalatnama, Lordship. Just today only telephonically instructed. Submits that he is going to file the Wakalatnama during the course of the day. Yes. In view of the opposite, let the matter be listed when. After 2 weeks. After 2 weeks, let the matter be listed after 2 weeks. In the meantime, in the interim order so passed earlier, shall continue. First in the next day.
matter number 17,
Notice upon respondent number 2, Lordship, interim completed.
Service, report of service of notice on respondent number 2 is still awaited. Let the matter be listed after 2 weeks.
Yes, obliged.
matter number 18,
None appeared for the appellant when the matter was called for. For interest of justice, let the matter be listed after 2 weeks.
matter number 22,
Your service report is awaited. I expect the respondent number 1.
Okay. The report of service on respondent number 1 and 2. 1 and 2. 1 and 2. Is still awaited. Let the matter be listed after 2 weeks.
Right.
In IA and MSc both. No, in IA only. MSc is not admitted.
Matter number 5,
MSc was admitted,
Not yet.
not admitted. So only IA was the order. Okay.
Lordship, the parties are represented, and these parties are represented. And at this stage, Lordship, I would pray for admitting the matter, this matter, and fix for the hearing.
Yeah, you have filed your vocal number. Yes, I filed a vocal. Parties are duly represented. This item number? 5. 5, it has come for what? Admission?
Admission.
Let the matter be listed. You don't want to do it today.
Lordship, fix for the hearing. Next.
Let the matter be fixed for hearing. The matter is already admitted.
Lordship,
This is come
fact
for
in the
admission.
nutshell is that, Lordship,
Huh?
Lordship, the fact in the nutshell is that the matters is basically a matrimonial dispute, Lordship.
Okay, let the matter be fixed for hearing. After 2 weeks. After 2 weeks.
If you have-
matter number 6,
Your Lordship. My lord, this petition is against the conviction. The petitioner herein was convicted for a period of 2 years with a fine of rupees 10,000. He is now in jail. Then he was convicted by judgment and order dated my lord 17/12/2020 by the Learned Judicial Magistrate First Class. Against it, we have filed an appeal. In the appeal also it was affirmed. Only main contention of the prosecution is that conviction was done only based on the medical report.
So we'll take it up on Thursday. Not today. Let the matter be listed on,
Disposal, my lord.
let us see on, let the matter, parties are duly represented, let the matter be listed on.
Charge date on
19
this as
19 will be difficult. 24th is the hearing date. 24th,
day after tomorrow.
tomorrow will be, there are a lot of matters fixed. There are, 13 is the Friday, court has to,
On 12.
24th we will fix it. 24th for disposal, can be disposal.
Plus
24th, let the matter be listed on 24th. 24th you do it.
now it's in 6 months in jail.
I understand,
Only 5 witnesses are there. Will not take time. Only 5.
no, that is not the thing, a lot of matters have been fixed. And today
also,
we
my
have
lord,
some,
solely based on the medical report, my lord, injury report, kindly see, my lord, in the paper book, page 7, the injury report. It cannot,
page 7,
page
Sir.
8, right, page 8 of the paper book.
what is there?
This is the injury report. So casually made by the medical officer, my lord.
It has been,
Cut injury,
and what is the, sentence?
2 years.
Hmm.
Cut injury, 12 inch in the head. Can it be believable, my lord? 12 inch. If it is 2-3 inch, there may be a case. And
Okay, we'll fix it up on Thursday then.
yeah,
Next Thursday, okay. We'll we'll try to dispose it of.
only 6 or 5,
Okay, well, 12 to fix.
12.
12 is Thursday, right? 12, let the matter be fixed on 12. Thursday.
matter number 7,
Yes, ma'am. Service upon respondent is my lord completed, my lord.
So matter, nobody is appearing.
Yes, my lord.
So we'll fix it up some other day.
Yes, my lord.
Okay, heard, Mr. So-and-so, the Learned Counsel appearing for the petitioner. Office note dated 4/12/2025 reveals that service on respondent number, sole respondent has already been completed. However, none has appeared for the respondent. In the interest of justice, let the matter be fixed after 2 weeks.
Yes, my lord, there is an interim date.
Interim orders for passed earlier shall continue in the next date of list.
Finish this.